mynews.studio.
A court decision has just recognized nature as a legal subject. Will this force governments and companies to answer directly for climate change?
Today is July 26, 2025. Let's begin with the basics. On July 3rd, the Inter-American Court of Human Rights issued what many are already calling a historic advisory opinion. But what exactly happened?
For the first time, an international court has recognized an independent right to a healthy climate as a fundamental human right. Previously, climate lawsuits had to link environmental harm to established rights, like health or life. With this ruling, people can now go to court directly on the climate issue itself.
Let me clarify. If you're, say, a community affected by rising sea levels or deforestation, you don't have to prove your health or property is at risk anymore. You can just claim your right to a healthy climate.
That's correct. On the other side, governments and companies now have to show that they're not infringing on that right. It's not enough to just follow existing rules. They need thorough climate risk assessments, transparent emissions reporting, and science-based targets.
That really changes what legal compliance looks like. But how did the court justify such a broad move?
The court began with the broader right to a healthy environment, then went further by recognizing nature itself as a subject of rights. They also classified the ban on irreversible environmental harm as a jus cogens norm.
Wait, jus cogens? That's one of those norms that can't be overridden, right? Like bans on torture or slavery?
Exactly. It means no country or company can opt out of this responsibility, even if they agree to do so. These duties are binding at the highest level.
The opinion also set out specific obligations. What exactly are states and companies now required to do?
There are several. States must adopt ambitious, science-based climate targets and regulate corporations to prevent environmental harm. They also have to protect vulnerable groups like indigenous peoples, Afro-descendant communities, youth, and environmental defenders, and ensure public participation, access to information, and justice on climate matters.
That's a significant workload. How did the court ensure the process was representative?
They opened the process to more than 260 amicus briefs and over 160 delegations. That's more participation than we've seen before, and it brought in the perspectives of those most affected by climate change.
So what now? Will this trigger a surge in lawsuits against governments and companies?
That's likely. This ruling gives individuals, communities, and civil society groups a new legal tool for climate litigation. They'll be able to hold governments and companies accountable both domestically and internationally. But turning these obligations into specific policies will be complicated, especially for countries with fewer resources or political resistance.
And if, say, a country or a large corporation just ignores the ruling, what happens?
Enforcement depends on domestic legal systems, civil society pressure, and international oversight. The 23 states that are part of the American Convention on Human Rights now have to align their laws and policies to this new standard. For companies, there are both reputational and legal risks if they ignore these duties, especially as climate litigation grows worldwide.
Could this kind of legal reasoning spread to other regions or courts? Are we looking at a global impact?
Legal experts think so. The Inter-American Court's detailed opinion could be a template for courts like the International Court of Justice or the African Court on Human and People's Rights. It creates a persuasive precedent, even if it's not technically binding outside the Americas.
But there are hurdles. Not every country even recognizes environmental rights, and judicial independence isn't always guaranteed.
That's true. Legal traditions vary, and some states don't have explicit environmental protections. Also, enforcement will depend on political will and the strength of institutions.
Even so, this feels like a turning point. Is it fair to say this could reshape global climate governance?
Yes, by confirming the right to a healthy climate and clarifying duties for states and companies, this decision empowers vulnerable communities and civil society worldwide. It could drive new policies, influence international negotiations, and inspire legal action that affects billions.
So in short, a single court decision has established a right to a healthy climate, created new duties, and opened the door to a new wave of climate accountability.
Now everyone will be watching how governments and companies respond. Will they adapt, resist, or lead? The precedent is set, and so is the pressure.
Thanks for joining us as we unpacked this landmark case.
Thank you for listening. This episode was brought to you by mynews.studio. Try it now for free.